Start.
Uh, Good evening, everyone. So, my today's topic is concept of pleadings under Code of Civil Procedure. Pleading is the foundation of litigation. It can be defined within Order 6 of the Civil Procedure Code. Order 6 Rule 1 of the CPC defines pleadings as plaint or written statement. The word plaint is undefined in the code. However, it can be said to be a statement of claim, a document which contains a material fact of which a suit is instituted in the court of law. The word written statement is also defined in the code in Food Corporation versus Yadav, Engineer and Contract. It has been defined as a term specific connotation ordinarily signifying a reply to the plaint filed, uh, filed by the plaintiff. According to the Cornell Law School, pleading is the beginning stage of lawsuit in which parties formally submit their claims or defenses. The objects of pleadings ascertain the actual issues between the parties. Pleadings state the issues to avoid surprise and the other party. Pleadings narrow down the area of conflict. Pleadings state the facts which need to be proved at the trial. The importance in pleadings determines the burden of proof. Pleadings it adds court in the final decision of the case. Pleadings enables the court to in the decision of the parties right parties. Pleadings enables the opposite party to know the case. The basic rules of pleadings are as follows. Pleading should state the facts. Second is the fact should be the material facts. Third is pleading should not state it in evidence. Then last is uh, pleadings in pleadings should be in concise form. The other rules of pleadings are as follows. Every pleading must be signed by the party or his pleader. Next is particulars with date should be stated wherever in misrepresentation, fraud, breach of trust, or undue influence must be pleaded. Third is the effect of the document shall be stated briefly where the contents of any document are material. Then we will discuss about the amendment of pleadings under CPC. Order 6, Rule 17 of the CPC talks about the amendment of pleadings. At any stage of proceedings, the court may allow the plaintiff or defendant to amend his uh, to amend his proceedings. The amendment to pleadings shall determine the real questions in controversy among the parties. What is meant by amendment of pleadings at any stage of proceedings? The 2002 amendment inserted the phrase at any stage, which means prior to trial. Then what were the procedures for amendment of pleadings? Either of the party, first is either of the party who are willing to amend their pleadings to write an application for amendment of pleadings to the concerned civil court and present the application to the concerned civil judge. Second is the applicant needs to pay court court fees under the Court Fees Act 1870. Third is the applicant needs to communicate require reason to amend their pleadings. Fourth is Now the judge in its discretion, the application on the grounds of whether the amendment is necessary, it determines the real questions in controversy between the parties, whether the amendment is necessary to deliver justice to both parties. Fifth is, after getting an approval from the court, the applicant needs to file the new pleading in the release of the order. Then last is, the applicant needs to submit the copy of amended pleading. So that's it, sir.